All right. Good morning, everybody who is logging on and tuning in on LinkedIn, Facebook, and YouTube. Thank you, as always, for taking time out of your busy schedules to listen in to what it is that I and my special guests are talking about on the show today. I'm going to keep the introduction very short because we have a tremendous amount of information to be able to go through today. I am so excited to have my very good friend Ronald Chapman Jr. Or the second back on my podcast today. Um, and we're going to stay very serious about this stuff because this is a serious conversation that impacts about 100 million Americans. And, we want to stick to the facts. We are not going to engage in any type of political conversation. So, irrespective of where you sit on this, on the right side of the fence, the left side of the fence, or in the middle, that's great. You could have those conversations with yourself and other people outside of this podcast, but we're going to stick to the facts. We're going to stick to what it is that we know and what we believe we are going to see. Ron Chapman is joining me today. He is a super lawyer. He's somebody I've had an opportunity to have a lot of interaction with over the years, and he is an admitted attorney to the Supreme Court. And given the fact that there are previous cases that we're going to address today, and we're going to address the impact of an executive order. What authority does a president of the United States actually have to police its citizens? I thought it would be critical to be able to have somebody at the highest level as a jurist sitting here with me today going through this. I do want to say I have turned on the chat function, so we are more than happy to take any and all questions, comments, concerns throughout the course of the podcast. Obviously, for those of you that are not joining us live, but you are joining us on the recorded version, welcome again. Those that are joining us on the podcast platforms, obviously, you can email us your questions once the show is over, and we'll be happy to try to get back with you. I think the biggest thing to keep in mind, and I want to say this right out of the gate, is that there are still a lot of unknowns at this point because of pending and potential litigation and legislative actions. And I think, Ron, that's something we could definitely talk about. And prior to getting onto the show, there's another aspect of the show that we want to talk about as we move on, which is the Merrick Garland memorandum that was put into place in July of 2021 that has some pretty interesting impact on the Justice Department and their ability to communicate with the White House and really what sort of authority they have given to the White House now that was kind of held in check by the Sessions and the Brand memos, as you and I were talking about. So again, I want to be clear out of the gate that this show is not taking a political stance and that I am not an anti-vaxxer. I am actually fully vaccinated, but I also believe in the freedom of choice, and I get concerned when the federal government does an overreach to the extent that this appears to be headed. So with that said, let's just get into the facts. Real quick, Ron, let me run down a few facts for you, and then I want to turn it over to you to get your take and your breakdown. So, again, on September 9th of this year, President Biden issued a series of executive orders that expanded mandatory vaccination requirements for COVID-19 and will apply to over 100 million U.S. workers. This includes vaccine mandates for federal workers and contractors, employees, or employers in the health sector, and all employers with over 100 employees. The federal government will implement this mandate through the new OSHA rule. And I will talk about that with Ron as we get going. So a couple of things. The executive order provide a broad outline of what employers and employees can expect, including the following. Employers with over 100 employees will need to implement policies requiring employees to obtain COVID-19 vaccines or undergo weekly testing for the virus. Failure, and listen to this, folks, Failure to comply with the mandate will result in significant fines for employers, potentially up to $14,000 per violation. Employers will be required to pay for weekly testing for unvaccinated employees, although the administration has indicated that such costs may be passed on to the employees. And finally, the last one that I want to talk about is that employees will be entitled to paid time off to obtain vaccinations. So I think just getting us started out of the gate, there's a ton to talk about before I even get into what the impact is for healthcare workers. So, Ron, thanks for giving me about 4 minutes to give that introduction and for being patient with me as I run through some of this. But let me go ahead and pause and get your takes as an attorney.
Yeah. So first, I have to say it's a pleasure to be on with the Joe Rogan of compliance. Wonderful to be here, and thanks for inviting me to talk about this topic. We've got a lot to unpack here. Just starting off, I think it's important for us to have a conversation about executive power. And as we've gone through the coronavirus pandemic, we've seen many attempts by the government to expand its power through these sorts of authorities. But for the most part, because the Trump administration wasn't really getting involved at the federal level, this was left to the states, right? It was the states who were enacting mask mandates and other issues related to employers. And that's really the realm in which the federal scheme and the constitutional scheme allows that stuff to happen. So let's talk about executive power for a second here. Biden, as the president, is appointed or elected to execute the laws of the United States. That's his primary function. So what are the laws of the United States? Well, we have the Constitution, right? And then we have other statutes that have been voted on by the legislature and become law that's signed by the president. Those are really the two sources of authority. There's a couple of others, but we need not talk about those right now. And the separation of powers is incredibly important, because once we allow the executive to start making laws, we don't have the checks and balances and the voice of the people that the Constitution mandates. So when we look at a vax mandate, like what has occurred with President Biden, we need to look for his source of authority. Now, there's a couple of them. You mentioned OSHA, and then also Medicare regulations is another vehicle that this is being put through. And there are a few other minor regulations, but just those two things right there account for, I think, over 100 million people, right? So President Biden, through an executive order, has made a decision for 100 million people, and we need to look for what statutes allow him to do that. Well, the interesting thing about OSHA regulations is that they're really inspection regulations when you look at them at their heart. OSHA was designed to make sure that workplaces are safe, and workplaces with more than 100 employees are required to abide by a heightened regulatory scheme. And so President Biden has said, we're going to look to OSHA regulations to have them create a rule that would allow this vax mandate to go into effect. Well, when OSHA creates a rule, they're bound, just like the president is, to create a rule based on existing authority that Congress has given them, right? So then we need to look at what authority Congress has given. And when you actually look at the authority granted to OSHA, there is no authority that comes even close to allowing a rule that doesn't just regulate inspections for safety in the federal workplace, but regulates what employees put into their body before going to the workplace, right? And that's important for us to look at. So, you know, I don't want to get my predictor hat on here and determine what's going to happen with this regulation, but we're going to see, and we've already seen unions file suit. We've already seen companies file suit. The courts in the United States are going to be backed up severely with litigation related to this. We're going to see multi-district litigation being combined, where a number of these cases will be combined together, and we're going to see them go up to the court. And I don't want to get too far ahead of ourselves here, but there's going to be a day where the Supreme Court is going to have to sit down and say, okay, what authority did President Biden have in order to create this or expand his executive power in this way? And they're going to look to see whether or not it was properly applied. And the construct of the court right now is not going to be friendly to expansion of executive authority. I can think of at least 6 votes right now that I would imagine would be squarely against any sort of expansion like this. Here's another issue that we have, and that is, and I think we're going to talk about this in more depth later, but back in 1905, there was a case, Jacobson versus Massachusetts, where a man, Jacobson, was from Sweden, I believe, and there was a smallpox vaccination requirement in Sweden. He went and got the vaccine, and he had a very, very terrible side effect from the vaccine, and I think his kids did as well. Well, he immigrated to the United States, probably not because of smallpox, for some other reason. He lands in Massachusetts. Massachusetts, around that time, 1905, I believe, created a law that mandated the smallpox vaccine. Right. And he respectfully declined to follow that law. And I think at that point in time, the fine for violating that law was $5. Yeah, $5. And now we have, in this case, a $14,000 fine per violation on the employer. And we also have, and we'll talk about this later, Medicare denial of payment and civil monetary penalties associated with not complying with the Medicare side of things here. So Jacobson refuses the vaccine, gets his $5 fine. Case trickles up to the Supreme Court, and I'm always amazed at how quickly cases got to the Supreme Court back in like 1905. It seemed like we had pretty good access to the courts. Now you need about $1 million and a whole team of attorneys to get you there, which the unions can do, but individual people can't these days.
Or just one Ron Chapman.
There you go. I mean, yeah, we're up there too. So I can't recall if he went to prison or not, but then the Supreme Court takes a look at the case. Now, let's talk about the differences between Jacobson versus Massachusetts and the Biden executive order. In Jacobson versus Massachusetts, Massachusetts has a police power. The states have been given authority by the Constitution to regulate the people and to make decisions for the people. And the reason why is because we're not just one big republic. We have a collection of states that are able to make decisions for people, and they can make better decisions than the federal government. That's traditionally what the Constitution has told us is the right way to do things. So the justice who ultimately wrote the opinion, and I can't recall who it was, determined that the states have a police power, and that police power may include requiring vaccinations for the citizens. And the 14th Amendment won't disrupt that police power, okay? Here's the difference. Joe Biden is the president of the United States. He's acting based on a statute that is unclear and doesn't include any clear vax mandate, and he's acting without police power. The federal government has no police power to regulate the citizens.
Right.
Primarily, its power relates to federal matters and things that would impact multiple states at the same time, but it's not given a general police power over the citizens of the United States. So the Supreme Court ruled in favor of Massachusetts in Jacobson versus Massachusetts. Jacobson's conviction for violating the max mandate stands. And I've seen that trickle up through some of the pundits as the case that protects President Biden's decision here. But I think that's a misapplication because this was a state case. This was a state law that was enacted by the state legislature. So we're even further removed from Joe Biden's executive authority. Now, let's ask ourselves, had Joe went to Congress and said, hey, Congress, we'd like you to make a law for a vax mandate, would they have done so? And I think we were talking about this before the show started, and it's very clear that one of the reasons he didn't do that is because he knew that he wouldn't get support from Congress. So we have to ask ourselves, is it okay for a president who knows that he's not going to get support from the recently and more closely elected people, Congress, who are elected to make decisions on behalf of us, if he can't get support of those people, does he then have the ability to make such a sweeping executive order that impacts well over 100 million people? In fact, I don't know that I believe those estimates. I think everybody in the United States is basically impacted. I mean, you would have to, in order to not fall into this, you would have to not work in a workplace over 100 people. You would have to not be an employee of the federal government or a contractor or any contract with the federal government. And then you would have to not be an employee of any hospital or medical facility that accepts Medicare. I will say that most of your constituents listening to the show right now qualify for this vax mandate simply because they work in the healthcare industry and it's heavily regulated, right?
Yeah. I think that's a great point, and you lead me right into where I wanted to go. So obviously, keep in mind right now, there's still a lot of speculation on what's going to happen in the healthcare sector with respect to the Centers for Medicare and Medicaid Services, or as we call it, Medicare. There is an interim final rule that will be coming out in early October. So we don't have an interim rule right now. There's been no comment period. My guess is, once we get this, it'll be somewhere between 30 to 60 days, which is the usual amount of time before Medicare moves with something. But let me just go through real quick, Ron, the 4 bullet points that are tied to healthcare and get your take on these. First, the mandate will likely apply to hospitals, nursing facilities, and other long-term care facilities, dialysis facilities, ambulatory surgery centers, home health agencies, hospice, clinical labs, ambulance providers, among other providers. And, they stop short to say among other providers. Now, folks, this is coming directly from the Biden-Harris executive order. This is how it's written. This is not me or some other pundit who's adding these words in here. It literally says among other providers who receive Medicare and Medicaid reimbursement as a condition for participating in the Medicare and Medicaid programs. Second, the expanded vaccination mandate is expected to cover over 50,000 healthcare organizations and over 17 million healthcare workers across the United States. Really interesting. In New York, I don't know if you saw this the other day, it's 2 or 3 days ago. One of the hospitals had to shut down their labor and delivery department, and they could handle no cases because all of their L&D nurses quit over the mandate that was being pushed out. And we're seeing this. I did a podcast yesterday with Dr. Matthew Kalinsky, and he's a internist, pediatrician, but he also is an entrepreneur. He owns staffing agencies, and the number of people coming to his staffing agencies now looking for work because they've walked away or they ended their employment with their current employer are now looking for other places to be able to go work. So they're flooded. So 2 more points, and then Ron, I want you to talk about these. The mandate will cover direct care staff and staff who are not involved in direct patient, resident, or clinical care. And finally, the mandate will apply broadly the workforce of covered settings, including employees, contractors, volunteers, and other staff of such institutions. So that was right to your point.
Yeah. I think we can assume that among others is going to mean anybody who accepts Medicare, Medicaid, and really anybody who works with those people and enters their facilities. I honestly think that's how this is going to be implemented. We can expect a final rule at some point in October. It's being drafted right now. It will be circulated for comment. You and I know very well that the notice and comment rulemaking procedures are largely a circus. It's just for show. It doesn't result in any meaningful change of the rule. And so the rule will be put through by CMS as it's enacted, and it will apply broadly to a lot of people. I don't want to digress here, but let me just go back to your comments about the concerns that some people have about this. In getting ready for the show, I was talking with somebody who works in my office, who I respect a lot. And she was literally in tears as I was telling her that I don't believe the vax mandate will stand because her and her husband desperately want to have kids. And the lack of research about the long-term effects of a first, second, or third vaccine really aren't that clear. And people are very, very concerned about making that decision to get the vaccination. And I feel like we're sidestepping a lot of those concerns. And I think that those concerns are very real. I got the vaccine, but I'm 38 years old. I have 3 kids. I'm not too worried about any long-term complications. Lived a decent life so far, but there's a lot of people out there who aren't me and who aren't in my position, who have very real fears and concerns. And so, we have to make mention of the lack of available information about the efficacy of the vaccine, about its long-term implications, and as I was listening to a law professor from NYU, Epstein, talk about this morning, we've also sort of assumed that the vaccine is really the best way to attack coronavirus, which remains to be seen. And these issues will be litigated at the federal level. The lawsuits that will come out of this won't just focus on executive authority, but they will also focus on the fact that the federal government is making a decision with a lack of clear available information while this is still an evolving issue, right? And one thing we know about the Supreme Court is that they don't like to make cases on a moving record. And what I mean by that is when information is still rapidly becoming available, this is one reason why the Supreme Court takes a long time to make a decision. We have to filter up through the courts. They need to be able to sit down and digest all of the available information. And the Supreme Court is going to be asked in this case very quickly to make a difficult decision based on a lack of solid scientific information. And that's what President Biden has put them in the position to have to do so quickly with executive orders. Congress didn't sit down and debate this. There wasn't experts and committee hearings about this efficacy. There's not a very full record developed. There's only a 2-page executive order. And what Epstein was talking about this morning as well was, the president was kind of putting the Supreme Court and other courts in a bad position by not creating a position paper discussing exactly why this was necessary. I implore all of the people out here listening to pull open the executive order and read those words yourself. It's on whitehouse.gov and you can read it and you'll realize, sure, it's easily digestible for the public, right? People can see it, but in it, it contains a lot of assumptions and decisions that are being made for you that don't have the corresponding research associated with it. And that's what I'm a little concerned about. So going back to Medicare and the rule, I assume this is going to be something that impacts everybody who works in the healthcare field. And here's the other thing, and this is important for everybody out there to understand. Medicare's way of punishing you for not complying with conditions of participation is prepayment review, right? Withholding funds from your facility, civil monetary penalties that can range in the millions and millions and millions of dollars. They almost have unfettered ability to fine you for violating these regulations. And all it really takes is a collection of staff members who refuse that you don't fire to implicate that rule and cause penalties. So very quickly, the hospitals, the large facilities and institutions are going to have to be making very, very difficult employment decisions in order to not get slapped by Medicare, right? And stay compliant, but keep their employees happy. We're going to see a revolt of the nurses unions and the other unions that are in these sorts of facilities as they're fighting to protect their employees from getting discharged, while the hospitals are fighting to prevent the excessive fines that are associated with violating Medicare regulations. And all of this happened basically overnight without warning. And that's what we're left with. This is going to be an issue that you and I are going to be talking about for months and months, and this is not going to go away quietly.
And as you were talking, one of the things that I started thinking about were the other lawsuits that could potentially be filed for individuals that suffer injury or long-term effects. It was interesting. I was listening to a virologist talking the other day, and then I was listening to another physician talking about, at this point right now, they say there's been no evidence of a link between the vaccine and infertility or birth defects. But the caveat to that was, but we don't know what could happen 5 years from now.
Yeah.
And that's the scary part about this thing. So again, a lot of things, there's a lot of potential different type of lawsuits that could be filed that could come out of this executive order. And I think, to your point, this thing is not as clear cut as people want it to appear to be. There's a lot of complexities to this, and there's a lot of potential things that could go sideways for the administration, for Congress, for the American workers and, employers around around our country. So we were talking about OSHA, right, and
Yeah.
their potential role. And I think it's really interesting, right, because what's anticipated is that the emergency temporary standard. So anytime you see a term called an ETS, it's referred to as an emergency temporary standard. And what they're saying is they're expecting this ETS to go into effect between 30 and 60 days. Now, the interesting thing to keep in mind about an ETS is that it can only be in effect for 6 months. This is the trick on this, right? So it's only able to be in effect for 6 months. And after the 6 months, it has to be replaced by a permanent OSHA standard, which an OSHA standard is required to undergo a formal rulemaking process. So it has to be promulgated into the law. So there is a very short window of opportunity for this ETS to be mandated to get 100 million American workers vaccinated under this executive order if they're able to carry it out, right?
Yeah, yeah. And I think, as you mentioned before the show started, these ETSs don't have the best track record. What was your data on that?
Yeah, let me speak to that real quick. So according to the Congressional Research Service, in the 9 times OSHA has issued an ETS prior to its COVID-19 healthcare ETS, the courts have fully vacated or stayed the ETS in 4 cases and partially vacated the ETS in 1 case. So 60% of the cases in total were either completely vacated or partially vacated. That's not a great track record for these things.
That is a terrible track record for any administrative body, honestly. Usually when an administrative body makes a rule, they have to go through great pains to make sure that they have the authority to make the rule, and it's backed by actual lawful authority. They've got teams of lawyers at OSHA poring over regulations to make sure that they have the proper authority. I will say that one of the reasons why they don't have the best track record is because, unlike other areas of the law or administrative regulations, labor unions have incredible power in this country to litigate, and they have access to the courts. But that's not a compliment to labor unions. It's sort of a criticism of our system, because other administrative regulations where there isn't this big body with the capability to file quick lawsuits, they get passed through and they don't face the same scrutiny, right? And this is one reason why, and I know we'll talk about the Garland Memo later, but one reason why we need to be very careful anytime we see the executive expanding their authority without the lawful authority to do so. Agencies are given a tremendous amount of deference to their rulemaking powers, as long as that is tied to an actual statute, right? If it's not, they don't get any deference whatsoever. Now, thankfully, I think the court is uniquely poised to answer these questions and to rein in the administrative powers, so we can get back to a country where Congress is making decisions. Regardless of if that Congress is red, blue, or purple, it doesn't matter to me.
Doesn't matter.
They need to be the ones sitting in the chair, casting votes on our behalf, because they are more closely associated with the people than the executive.
Well, because the people who put them there.
Exactly. Yep.
Yeah. So exactly. a couple of quick things, and we'll keep moving through this. One thing that stood out to me is, under the Fair Labor Standard Act, employers must pay non-exempt employees for their time spent undergoing testing during the workday. This likely includes required testing occurring on employees' days off if such testing is necessary to perform their jobs safely and effectively during the pandemic. Second is religious objections. And this one's really interesting because we talked about the state of New York, and we could quickly talk about that. But under federal law, religious objections are protected even when they are not supported by a formal religious group. And employers need to be able to seek further verification only in rare circumstances if there is a specific reason to doubt that the employee's objection is religion-based. And it says, notably, political and philosophical objections are not protected by federal anti-discrimination law.
Yeah. So, this is worded very carefully because we have a large body of conscientious objector litigation and case law to look at. And I think, I can't remember the exact words that the court used, but in order to be have a religious objection, a valid religious objection, this needs to be a deeply held belief by a religion that the government essentially recognizes as being a religion. Now, that doesn't mean that it has to have a certain number of members, an actual church, an actual book, right? It can be less formal than that, but they want to make sure, and I understand this, that when a religious objection is being made, it's not purely philosophical or political, couched as some form of religious objection. So you'd want to see if that person had been a member of that religion prior to raising the objection, right? Whether that religion actually holds that belief, and whether that religion is a religion. And so, political objections to a mandate just really will never be considered, because if the law says you have to do it, you have to do it regardless. We don't just get to say, I want to drive 50 miles an hour on a 25-mile-an-hour road because politically I believe that I should be able to do that, right? But that's why we need to have laws in place that we actually respect and are based on good science. So looking at those conscientious objector type cases, we see that the courts have done a pretty good job of recognizing what is actually a deeply held religious belief and what might not be somebody maybe just trying to escape the draft because they want to escape the draft. And in this case, I think that the state of New York, as you mentioned before, actually did away with religious objections. I don't think that that survives a First Amendment challenge. And I think that this carve out in the OSHA regulations is probably narrowly tailored enough to avoid a First Amendment challenge. But again, I expect those First Amendment challenges to bubble up in the courts. I expect that religious bodies and organizations will be filing that aspect of the cases. And I think we're going to meet in the middle right at the Supreme Court for a pretty heavy oral argument that I will be tuning into. Perhaps we should be live while this thing is going on so we can talk about it. Because I think it's going to be interesting.
Absolutely, because I know we would be giving the facts as opposed to opinions. Now, I want to tie this into what the state of New York has done, because this picks up on the religious aspect and it picks up on some other things. So this is how it was worded by the state of New York. The emergency regulations are premised on the view that within healthcare settings, unvaccinated personnel pose an unacceptably high risk of both acquiring COVID-19 and transmitting the disease to colleagues, vulnerable patients, and residents, thereby exacerbating the risk of complications and staffing shortages. So this is the position that the state of New York has taken. And they actually overrode the local government in New York City in a certain respect. Real quick, two points that I want to make, and then obviously, Ron, I want to get your take on these. The first one is no testing out option is what they call it. So last month in August, New York City had announced that employees at city-run healthcare facilities would be required to submit proof of vaccination, or in the alternative, have the ability to opt out and submit to weekly COVID-19 testing and provide proof of a negative test. In consideration of the new state mandate in emergency regulations, New York City's regulations, according to the state of New York, appear to be outdated. And the opt-out testing alternative to vaccination will no longer be allowed. So they said, sorry.
Yeah. I think that it's clear that the legislature in New York read Jacobson's versus Massachusetts and has realized that likely the court would make a similar decision and protect them, or at least they're protected by existing precedent, right? And in Jacobson, the law didn't have a religious exemption, and they think that that will survive scrutiny by the courts. In Jacobson, there was no testing out option. It was a mandatory smallpox vaccination for everybody. So the challenge to the New York law is not likely to be an improper use of police power. What it's likely to be is focused on the difference between the smallpox vaccine in 1905 and the limited information that we have about the coronavirus vaccine in 2020 and 2021. And I expect that's where challengers will launch their challenge, because they're not likely to be successful taking on, in light of Jacobson, the police power of the state to be able to enact this rule. But I think that they have pretty good footing on the differences between the smallpox vaccination and coronavirus. Smallpox is basically the same disease then as it is today, right? We still see it floating around today. Coronavirus, we're in many different iterations of this virus, and many of them have been resistant to vaccines. So there's a very real open question as to whether or not one coronavirus vaccine actually prevents further spread of the virus and is the way to satisfy this public health emergency that we have. Government regulations need to be narrowly tailored to a compelling government interest under this standard of scrutiny that we have here. And a wide sweeping vaccination program that is not based on the best research available, where information is still evolving, may not be narrowly tailored to achieve a compelling government interest, because the government may not have a compelling government interest in forcing a vaccine that may not be effective. And that's really where the challenge will lie. And I expect that we shall see that probably bubble up a little bit earlier than we get the Supreme Court to act on the vaccination mandate for the executive order.
And right now, the latest count, there are 19 variants of the coronavirus. The latest one that is showing resistance to the vaccine is the Mu, MU, but there are others. So again, I think to your point, very, very well made. I mean, this isn't just a smallpox where it's been consistent as, a virus or whatever, it is. This is something that continues to mutate, and it continues to evolve. And that's part of the concern. The last thing that I wanted to point out, and then I want to jump into the Garland Memo, because it, as you said, it ties directly into what we're talking about now with COVID-19. But the last thing that I wanted to point out about the state of New York is that the emergency regulations permit no exemption based on religious beliefs or practice. Ultimately, covered entities are permitted to terminate covered personnel who are not fully vaccinated and do not have a valid medical exemption if they are unable to ensure individuals are not engaged in patient resident care or exposed to other personnel. It's pretty wild.
Yeah, I think that's pretty far-reaching. Again, I actually think that the New York regulation or law has a better chance of survival than the Biden executive order, just because of that Jacobson case, unless a court determines that a vaccine mandate isn't a compelling government interest. And I suppose we'll see how that shakes out. I'm very interested in staying tuned to that fight. But yeah, let's talk Garland Memo. It's
let's do that.
Very connected.
And it was driving me crazy trying to figure out who actually wrote the opinion for Jacobson in Massachusetts. It was John Marshall Harlan. Good old John Marshall Harlan. You know him.
Yep, absolutely. I wish that we could revive some of these justices and see what their take would be on some of the modern issues, right? When I reread the Jacobson decision, they just dove straight into the law, right? They didn't have to cite 15 different regulations and stack them one on top of another. And it just speaks to a simpler day of United States jurisprudence, where you could really attack the heart of an issue and relate it to the Constitution. They had a much easier job back then. And that's because they probably had about, 12 billion less laws to analyze during their daily work.
Yeah. And it's interesting. In thinking about this, I wonder if the King case from 1922 will also surface as something that people will also want to take a look at. I'm trying to remember. It's
that was Zucht v. King, I think.
And Zucht v. King, 1922.
Yep, that was whether a school system could refuse admission to a student who refused a vaccination. Very similar result there. I think Jacobson really paved the way for Zucht. I think the court doubled down on its analysis. It is a more recent case. You know, they teach us in law school that if you're relying on something from 1905, you should probably continue your research. 1922 doesn't really get you any better,
No.
honestly.
All right, because we're talking about the impact of the executive orders, right, and the might of the pen, and it seems that Attorney General Garland produced a memorandum on the Justice Department communications with the White House, and this was released on Wednesday, July 21st of 2021. And what it basically says is, quote unquote, the success of the Department of Justice depends on the trust of the American people, end quote. Wrote Attorney General Garland. That trust must be earned every day, and we can do so only through our adherence in the longstanding departmental norms of independence from inappropriate influences, the principled exercise of discretion, and the treatment of like cases alike. So I don't mean to smirk or chuckle through some of that, but I'm going to stop because I really want your position and I want folks to hear your analysis on this.
Yeah, let's lay the groundwork here,
Please.
And so that everybody can understand how important this is to their daily operations. And I'll go back through it just like I did with executive power. So agencies like CMS and departments have the ability to create rules that bind private organizations, public organizations, and specifically in the healthcare context, we have rules that are promulgated, meaning they go through their formal rulemaking process. And that's the way that an agency can address a matter of importance using its specified knowledge that it has as an agency. And this makes sense, right? We can't have Congress getting together every time a Medicare rule needs to be changed, right? Nothing would ever get done in our society, and we wouldn't be able to have an effective system of laws. So we've created administrative regulations, and we've delegated creating those regulations to the agencies, and the agencies just have one responsibility to go through, and that is they have to publish the regulation, they have to allow a notice and comment rule period, and people's voices can be heard, and entities' voices can be heard about those regulations in order to make sure that they are sort of forged in at least some fire of due process, right? And this is really a due process proceeding. Well, that's great, but there's also this other thing that has happened. Agencies have decided to write unofficial guidance documents. Medicare Claims Processing Manual is probably the one that impacts most of the people that are listening to us today. They write informal guidance documents, and then what they do is they tie them to administrative regulations. Everybody who bills Medicare signs an 855 or some form of it and agrees to abide by Medicare's rules and regulations, right? Medicare's rules and regulations include, according to agency precedent, the Medicare Claims Processing Manual. So essentially, the Medicare Claims Processing Manual has become a regulation in and of itself because it's been tied to a regulation, right? Now, what we've done when we do that is we require everybody who operates in the healthcare system to abide by a book that was drafted by people and didn't go through a formal due process rulemaking proceeding. There's a case, Azar versus Alina. Can't remember what year that was, a couple years ago, maybe 2019. And in that case, the Supreme Court very clearly said that these manuals, these books, these papers published by CMS, these things that you and I, compliance professionals, pore over to see how the agency is interpreting its regulations, they can't be used to bind a private entity. So no more can a federal prosecutor go into court and say you violated section IB 1.1C paren 4 of the Medicare Claims Processing Manual, and therefore you owe us $20 billion, right?
That's right.
And you think I'm joking, right?
That's how it happens.
That's actually how it happens, right?
Yeah.
So the Supreme Court very clearly said that, and that's why I like the composition of the court these days, because they're capable of making the hard decisions, and they say, listen, an author of a manual that was published by the government does not have any more rulemaking authority than you or I. So that case comes out, and in order to make sure that federal prosecutors are adhering to that case, Azar versus Alina, Jeff Sessions and Brand, who was, I think, the deputy AG at the time in 2017 and 2018, knowing that Azar or Alina was about to be precedent, they wrote memos. And those memos say, consistent with what President Trump tried to do in cutting bureaucratic red tape, they say that federal prosecutors can't use documents that didn't go through the formal rulemaking process in order to bind parties. So in False Claims Act litigation, I believe in healthcare fraud litigation, and even in some of CMS's own internal administrative proceedings related to exclusion or monetary penalties, you can't use these unpromulgated documents. Well, fast forward to Merrick Garland being the Attorney General of the United States and President Biden being the president, we see in August, I think August 21st, I think it was originally maybe published August 1st, a memo that comes out that is very, very unclear. Let's just start there. The memo recognizes Alina, it recognizes the Brand memo, and it recognizes the now long-held precedent that unpromulgated guidance documents do not have the force and effect of law. It recognizes that. But it also encourages prosecutors to use those documents to show scienter, meaning knowledge of regulations, to show intent that you broke the regulation, to also inform judges as to an agency's position on how those regulations must be interpreted. And I think Scalia once wrote a long time ago that an agency does not have the ability to interpret its own regulations in that context through unpromulgated documents. But I think Merrick Garland appears to be taking a run at that with his new memo. So the memo is unclear, but what we do know is that now prosecutors have been given the green light. And here's what this means. Previously, if you violated an LCD, you wouldn't expect a healthcare fraud prosecution based solely on violation of an LCD.
That's right.
Or a healthcare fraud prosecution based solely on violation of some part of the Medicare claims processing manual or the benefit manual. Now, federal prosecutors are free to interpret those guidance documents to determine whether or not somebody intended to violate the rules. And here's the problem. I've often wanted to do this, and one day I will do it, and I will tell you when I do it, Sean, so that you can be there to see it. But many times I argue to a jury, how in the world could this doctor, in a federal criminal case, how in the world could this doctor have had knowledge of every single Medicare rule that is out there when the government tries to use that rule to say he knew of the rule and he decided to break it and that was fraud? I would love to take every single document and put it on a cart. In fact, we'd probably need to take the jury on a field trip to a library somewhere.
That's right.
Right? And say, these are the amount of rules that every doctor, every healthcare provider, every entity is required to know and follow, right? It's impossible. We could spend a lifetime of reading and research and never really understand these rules. And even after reading these rules, you and I know, and everybody out there in your audience knows, that reading these rules is way more complicated than just reading a book.
That's right.
You have to compare multiple laws, multiple sections against each other, and interpretation is a matter of hundreds of pages of jurisprudence based on one rule, and is a very difficult thing to conceptualize. So to the extent that the federal government thinks that it can point to a rule in some government manual that wasn't published to everybody and say, this is a rule the doctor knew, violated it, interpreted it differently, and that's the basis of a false claims case or a fraud case, well, that reality is back into existence now based on the Garland Memo. And that's very important for everybody listening out there, because these documents will be used. And given that we've seen that President Biden has the ability and I would say has decided to use the pen in this way, right. And Merrick Garland and CMS are also going to follow suit, we can see that there's going to be rapid fire rules coming our way. They're going to be very difficult to follow. They're going to be unpromulgated and not published to everybody. And they're going to be used against the people out there for the government to try to take money back, a lot of money. So stick close to your compliance, folks. Yeah. Make sure you get a legal analysis on just about everything, because the one thing that saves you from all that hassle is a good advice memo written by an attorney after researching the rules and the laws and letting you know that this is an okay thing to do or this is a not okay thing to do, that still remains an affirmative defense to any false claims action or any healthcare fraud action. And that's really what you all need to do to protect yourself.
Yeah, I think that's outstanding advice. And yeah, I definitely want to be there the day that you decide to walk a jury down to the Library of Congress or over to the CMS building. And you know, the funny thing is, if you just say, forget about all of the Medicare rules and regulations, and you just tie the rules and regulations that are specific to a specialty to a provider.
Yep.
They stretch football fields.
Yeah, I mean, just look at E&M coding and incident 2, right?
My two favorite topics.
Your two favorite topics, and your testimony on that is very clear and concise, and you do a great job of boiling that down. I just mentioned, I'm arguing this on behalf of a provider in Kentucky right now who's facing prosecution related to E&M coding. A study was conducted where they took 600 physicians and gave them the same medical records to code with an E&M code. And then they gave those same records to, I think, 7 or 8 experts in the field of E&M coding. And the study determined that the physicians only got it right about 48% of the time.
That's right.
Yeah.
Is that not unbelievable? And then all you have to do is go back to the 2015 OIG study that said greater than 50% of all evaluation and management services were billed between 2010 and 2015 incorrectly.
Yep.
Greater than 50%.
So we have the government still seeking indictment against providers for improper selection of E&M coding. But we have the government also admitting that these rules are so complicated that the average physician can't understand them. And I'm just perplexed. And that's why I spend my career fighting against this sort of executive expansion and on behalf of providers. And healthcare law has been the appropriate vehicle for me to do that. I mean, it's the one place where we're intersecting with the government constantly on novel and complex issues related to regulations. And it's been a joy to work in this profession and obviously to work alongside you. But it's a shame that we have to be here.
Yeah, it is. And, you know, after 26 years, I still have as much passion today as I did the day I got into this. Obviously, things are a lot more complex now than what they were in, 1989 when I started, but really doing this work in 1995 when I really got into the compliance role of things. But I love what I do, and I'm going to keep doing it, and I'll hang around for as long as people ask me to. And when they stop asking, then I'll head off to Montana, and I'll go off grid, and that's where I'll stay. So, all right. So I think at this point we have talked exhaustively about the executive order that was issued by the Biden-Harris administration. Again, I want to make sure that everybody understands at this point right now that there is still a lot of stuff up in the air. With regard to Medicare, we are still waiting for the interim final rule in the comment period. That's going to be supposed to be coming out early October. We'll see what happens with that. We're going to continue to monitor what goes on with the ETS for OSHA and the implementation, if they hold true for the 30 to 60 days. Again, I think we're also going to take a harder look at the Garland Memo and see what comes out of that from case law and what new cases, because they didn't just add an arrow back into the quiver of the prosecutors. They gave them landmines, basically.
Yeah, absolutely. They did. And here's the other thing that I failed to mention earlier. It's not that the Garland Memo was published with some sort of fanfare. In fact, I don't even think it appears on the Department of Justice official website. It was something that erased 2 very important memos for people when looking at compliance. And it was done without any fanfare whatsoever and provided clear direction to federal prosecutors on how to change the way they see their cases. Right. It's almost as if Garland didn't want people to know that this was happening. And when I realized that, and I realized that this memo was put forward in July, and I was just seeing it in late August, Well, I thought, well, I better call Sean and see what we can do about getting this out to people because it's a big, important development.
Yeah, they actually wound up going back and they did put it onto the DOJ's website, and they attached the memo. Yeah, they attached a memorandum to it from July 21st. But to your point, it was not there in the very beginning. So
yeah,
I will make sure that I make the links available a little bit later on today on my LinkedIn blog page for the items that we talked about today. And I'll make sure that I link to the Garland memo as well as the actual attachments that go with it. And I will make sure that folks know how to get in touch with you, my good friend, Ron Chapman II. Ladies and gentlemen, this will bring us to the end of our breaking news, special executive order, and Garland memo breakdown. I hope that you all found this to be beneficial. If you did, please spread the word about the Compliance Guy podcast. In just 4.5 months, we have had more than 35,000 views of our podcast. We can't thank you all enough for tuning in, spending time, and checking out what it is that we have going on and what we're talking about. Again, I want to extend my gratitude and my sincere appreciation to my very good friend and super lawyer, Ronald Chapman II of the Chapman Law Group, for being here today. And again, to each and every single one of you, thank you. Be good to yourself, but more importantly, be good to each other. I'm Sean Weiss, and until next time, I will try to do better. Thank you.
Thank you, Sean.
Thank you.